Hi, and welcome to this Law Study Club video to help you to revise manslaughter by diminished responsibility for A-level law. In this tutorial, we're going to quickly recap what we mean by voluntary manslaughter, and then we're going to dive straight into the requirements of the special defence. For a fuller explanation of voluntary manslaughter, look for the tutorial video on loss of control manslaughter. But for now, we just need to remember that voluntary manslaughter means that the defendant has met the actus reus and mens rea requirements for murder, but has a special defence that explains why they had the mens rea and therefore reduces their liability. In this video, we're focused on the second of those special defences, diminished responsibility. Diminished responsibility is relatively straightforward. The key thing to do is to know clearly the difference between the requirements of a diminished responsibility special defence and the requirements of an insanity defence. Now, the requirements of the diminished responsibility defence come from section 52 of the Coroners and Justice Act 2009, and they are that the defendant was suffering from an abnormality of mental functioning, which arose from a recognised medical condition, which substantially impaired the defendant's ability to understand the nature of their conduct, form a rational judgment, or exercise self-control, and which provides an explanation for the defendant's conduct. So if we work through those requirements in turn and we start with the abnormality of mental functioning, we know from R.V. Byrne that that means a state of mind so different from that of ordinary human beings that the reasonable man would term it abnormal. So effectively, it's left up to the jury to decide whether someone's mental functioning is abnormal. Now, the statute also says that that abnormality has to come from a recognised medical condition, which we can find on something like the World Health Organization's list of diseases, known as the ICD. But we also have case law to help us. So we know from R.V. Conroy that autism is a recognised medical condition, and we know from R.V. Squelch that paranoid personality disorder is a recognised medical condition. So now if we move on to the requirement relating to substantial impairment, section 52(1)(1) of the Coroners and Justice Act says that the abnormality of mental functioning must have substantially impaired the defendant's ability to do one of three things: to understand the nature of their conduct, to form a rational judgment, or to exercise self-control. Now, we might ask what we mean by substantially impaired, but again we can get an answer from R.V. Byrne. So in R.V. Byrne, the Court of Appeal said that substantial isn't actually a word that needs any more explanation for a jury because it has its normal meaning, and this was supported again in R.V. Lloyd. But in R.V. Goals, the Supreme Court said that the decisions in Byrne and Lloyd are still good law, but if a judge does feel like there needs to be any more explanation of what the word substantial means, they should explain it to the jury as important or weighty. So we've worked through the meanings of abnormality of mental functioning, recognised medical condition, and substantial impairment. The final requirement, that the abnormality provides an explanation for the defendant's conduct, just means that there must be a causal link between the defendant's conduct and the killing. So the abnormality of mental functioning doesn't have to be the only cause, it just has to be a significant cause. Things become slightly more complicated if the defendant has a potential diminished responsibility defence, but intoxication is also involved. So in R.V. Dowds, the defendant tried to argue that acute intoxication was a recognised medical condition, but this was rejected by the courts. So being drunk on its own doesn't provide a diminished responsibility defence. In R.V. Deachman, the House of Lords held that where the defendant has a recognised medical condition and is intoxicated, the jury needs to decide whether, despite the intoxication, the defendant's mental abnormality substantially impaired their abilities. In other words, the intoxication itself is to be ignored. But it's also been held in R.V. Wood and R.V. Stewart that diagnosed alcohol dependence syndrome is a recognised medical condition. This means that if the defendant acted because of their ADS, either because they involuntarily drank or because alcohol has damaged their mental functioning over time, the defence might be available. So now let's check our understanding of diminished responsibility by working through this scenario. Beth and William were married. William suffered from severe depression for which he was being treated with strong medication. In order to make sure he took his tablets, Beth handed them to William each morning. William's condition meant that he believed the medication was slowly killing him and that Beth knew this. One day he crushed a substantial number of tablets into Beth's drink and gave it to her. Beth died as a result. Sometimes a question might ask you to work through the defendant's liability for the victim's death, in which case you would need to construct William's liability for murder and then work through the special defence. But sometimes the question will ask you to assume that the requirements of murder have been met and just to assess whether the special defence would be successful. For our purposes, we're going to assume that William has met the actus reus and mens rea requirements for murder, and we're just going to decide whether a defence of diminished responsibility would be successful. If you want to work through the scenario independently, pause the video now and then hit play to get a worked solution. So we need to work through those 4 requirements from section 52 of the Coroners and Justice Act, starting with an abnormality of mental functioning arising from a recognised medical condition. We know from R.V. Byrne that the abnormality just means something that a reasonable person would say is not normal, and the jury would almost certainly say here that William's belief that Beth was trying to kill him through the medication was not normal. We can also see that William is being treated for severe depression, which is a recognised medical condition. Now, you don't need to spend hours looking through the World Health Organization list of diseases in case one comes up in the exam. The scenario question will be pretty clear in its wording whether something is or isn't a recognised medical condition by telling you, for example, that it's been diagnosed or that the defendant is receiving medical treatment for it. So now we need to establish whether William's abnormal mental functioning substantially impaired his ability to do one of those 3 things: to understand the nature of his conduct, to form a rational judgment, or to exercise self-control. William's misreading of the reason why Beth is handing him the tablets every day is definitely not a rational judgment, and we could also argue that his belief that he's essentially acting in self-defence by putting the tablets into Beth's drink shows that his ability to understand the nature of his own conduct has been substantially impaired. Finally, we just need to check for a causal link between William's abnormal mental functioning and the killing, which is clearly established by the fact that the killing of Beth is in direct response to, and in a similar way to, the way in which he believes Beth is trying to kill him. So William's defence of diminished responsibility would be successful. Now remember, this doesn't mean that William escapes liability completely. Instead, it just reduces his liability and avoids the mandatory life sentence for murder. Instead, William would be found guilty of manslaughter by diminished responsibility and would be sentenced to a minimum of 3 years in prison and a maximum of life. Hit subscribe to get notifications on new tutorial videos and follow the link in the description to lawstudyclub.co.uk, where you can find up-to-date revision guides, case lists and loads more resources for A-level law.